very warm good morning to all of you. Now, today we are going to discuss MP Civil Judge question paper of 2017, in which in the last classes we have discussed till question number 50. So, if you people haven't checked it out, those videos, please go check it out. And today we are going to discuss some of the questions from MP local laws. Then moving further, we are going to discuss some of the questions from specifically from your Indian Evidence Act and some of the questions from Indian Penal Code, that is IPC. So let's start today's discussion. Now, if you people haven't followed up our channel till now, please go and follow up our channel and don't forget to press the like button, right? If you like the videos, and don't forget to subscribe to the channel. Along with that, we have already started MP Civil Judge Prelims crash course. Just do check it out, link is in the description box. And let's start today's discussion. So the first question for the day is from your MP Accommodation Control Act, question number 51. The question is, a landlord who recovers the possession of an accommodation under a court's decree passed under section 12(1)(e), 12 clause 1 subclause E of MP Accommodation Control Act can relent it within 2 years of obtaining such possession. So the question is simply asking, when a particular person got the accommodation of a property under a court's decree under section 12 clause 1 clause E, then in that case, in which of the following cases the owner of that land, the landlord, can relent his land within 2 years of obtaining such possession? Option 1, with the permission of the court. Option 2, with the permission of rent controlling authority. Option 3, with the permission of both of them. And option 4, without the permission of anyone, right? So what should be the correct answer? Question number 51. A landlord who recovers the possession of an accommodation under a court's decree passed under section 12(1)(e) of MP Accommodation Control Act can relet it within 2 years of obtaining such possession. Option 1, with the permission of the court. Option 2, with the permission of rent controlling authority. Option 3, with the permission of both of them. And option 4, with the permission of anyone. So its correct answer should be B for Bangalore, that is with the permission of rent controlling authority. So if the rent controlling authority permits, even if a person got the property for his personal use, usually they are barred to relet such property within a span of 2 years of getting the property, but they can do the same, right? Question number 52. Which proposition is correct? So you have to find the correct proposition. Out of these 4 propositions, only one proposition is correct, rest all other propositions are incorrect. So we have to find the correct proposition. First one, a landlord can file a suit for eviction on bona fide grounds. Option 2, owner cannot file a suit for eviction on bona fide grounds. Option 3, the landlord must be the owner of accommodation to file a suit for eviction on the ground of bona fide need. And 4, either landlord or owner can file the suit for eviction on the ground of bona fide need. So what should be the correct answer? A landlord can file a suit for eviction on bona fide ground. A landlord cannot file a suit for eviction on bona fide ground. The landlord must be the owner of accommodation to file a suit for eviction on the bona fide need. And last, either landlord or owner can file a suit for eviction on the ground of bona fide need. So what should be the correct answer? We have to find the correct proposition. Yes, what should be the correct answer? Its correct answer will be your option number 3, that is the landlord must be the owner of accommodation to file a suit for eviction on the ground of bona fide need. Next question. This is purely a section number based provision based question. What they are stating in this question: if the tenant denies the title of the landlord and set up title in himself in the written statement, it's ground for eviction under section 12(1)(b), 12(1)(c), 12(1)(d), 12(1)(k of MPLRC. You can read this question. If the tenant denies the title of landlord and set up the title in himself in the written statement, it's ground for eviction under this section 12(1)(b), 12(1)(c), 12(1)(d and 12(1)(k. Ankita ji is saying 52 ka yes. Ankita ji, 52 ka 3 is the correct answer. Question number 53. What should be the correct answer? If the tenant denies the title of the landlord and set up title in himself in the written statement, its ground for eviction is a ground of eviction under section 12(1)(b), 12(1)(c), 12(1)(d and 12(1)(k of MP Accommodation Control Act. So what should be the correct answer of this particular question? Question number 53. Yes. Question number 53 ka correct answer is 2. That is under 12(1)(c) of MP Accommodation Control Act. Right? Next question. Question number 54. If any landlord contravenes the provision of subsection 1 of section 38 of MP Accommodation Control Act 1961, he shall be punishable with the imprisonment for a term which may extend to option 1 15 days, option 2 1 month, option 3 2 months, option 4 3 months. 15 days, 1 month, 2 months, 3 months. So what they are saying, yes Ankita ji, its correct answer is 53 ka correct answer is 12(1)(c), not 12(1)(d). Right? Question number 54. If any landlord contravenes the provision of subsection 1 of section 38 of MP Accommodation Control Act 1961, he shall be punishable with the imprisonment for a term which may extend to 15 days, 1 month, 2 months and 3 months. What should be the correct answer? 15 days, 1 month, 2 months and 3 months. Question number 54. So its correct answer is your option 4, that is 3 months. Right? Let's move towards next question, that is your question number 55. A landlord has acquired an accommodation by transfer. He cannot sue for the eviction on the ground of bona fide requirement under section 12(1)(e). Yes, Harshvardhan, Ankita, both of you are correct. 54 ka D or 4th is the correct answer. Question number 55. A landlord has acquired an accommodation by transfer. He cannot sue for the eviction on the ground of bona fide requirements under section 12(1)(e) or 12(1)(f) of Accommodation Control Act 1961 before completing the period of option 1 6 months, option 2 1 year, option 3 2 year, option 4 3 months. What should be the correct answer? Question number 55. What should be the correct answer? Hanji. A landlord has acquired an accommodation by transfer. He cannot sue for eviction on the ground of bona fide requirements under section 12(1)(e) or 12(1)(f) of MP Accommodation Control Act 1961 before completing the period of 6 months, 1 year, 2 year and 3 months. What should be the correct answer? Its correct answer is 1 year. That is option number 2. Right? Next question. Question number 56. Abadi means. Now this is the question from your MP LRC, MP Land Revenue Code. Right? So Abadi means, this is the particular question which is asked a lot. Yes, Harshvardhan ji, 55 ka 2 is second, B is the correct answer. Abadi means, first, the area reserved in a village in an urban area. Yes, Ankita Gupta ji, 55 ka 2 is the correct answer. Abadi means, option 1, the area reserved in a village in an urban area for the purpose of resident of inhabitants. Option 2, the area reserved in a village in a non-urban area for the resident of its inhabitants. Option 3, agricultural land in non-urban area. Option 4, land held as occupancy tenant in non-urban area. Question number 56, what should be the correct answer? Abadi means the area reserved in a village in an urban area for the purpose of resident of its inhabitants. Option 2, the area reserved in a village in a non-urban area for the residence of the inhabitants. Option 3, agriculture land in non-urban area. And option 4, land held as occupancy tenant in non-urban area. So what should be the correct answer? 56. Question number 56. Its correct answer is B for Bangalore, or option number 2. That is the area reserved in a village in a non-urban area for the residence of its inhabitant. Right? Yes, Ankita Gupta ji, 56 ka 2 is the correct answer. Question number 57. Whether civil court can declare the entries in the record of right as null and void. Whether civil court can declare the entries in the record of rights as null and void. Option 1, no, only revenue court has jurisdiction. Yes, Harshvardhan ji, 56 ka second is the correct answer. Option 2, yes, civil court has jurisdiction. Option 3, jurisdiction of civil court is barred under section 257 of MP LRC. Option 4, yes, but with the permission of High Court. Question number 57, what should be the correct answer? Whether civil court can declare the entries in the record of rights as null and void. Option 1, no, only revenue court has jurisdiction. Option 2, yes, civil court has jurisdiction. Option 3, jurisdiction of the civil court is barred under section 257 of MP LRC. And option 4, yes, but with the permission of High Court. Question number 57, what should be the correct answer? Its correct answer is your option 2 or B, that is, yes, civil court has jurisdiction to declare the entries record of rights as null and void. Right? Next question, question number 58, that is, the Tehsildar before whom a dispute of title is raised in partition proceeding of an agricultural holding should. Option 1, dismiss the proceeding and direct the parties to resolve the title dispute through civil court. Option 2, ignore the question and proceed to partition the holding in accordance with the entries in the records of right. Ankita Gupta ji is saying 57 ka A. It will not be A, Ankita ji, it will be B. Right? Option number 3, stay the partition proceeding for a period of 3 months to facilitate parties to the suit, a civil suit for determination of dispute. Fourth, decide the dispute of the title himself. So when a particular matter has been sent for partition proceeding of an agricultural holding before Tehsildar, what he can do? First, dismiss the proceeding and direct the parties to resolve the title dispute through civil court. Option 2, ignore the question and proceed to partition the holding in accordance with the entries in the record of rights. Option 3, stay the partition proceeding for a period of 3 months to facilitate the parties to institute a civil suit for determination of dispute. And fourth, is saying decide the dispute of the title by himself. So its correct answer is 3. Yes, Harshvardhanji, you are correct. Its answer will be option 3. That is, stay the proceeding for 3 months and request the parties to go to a civil court. Yes, Ankita Gupta ji are also correct. Question number 59. Now this particular question is quite common in MP, even in Chhattisgarh exams as well. Okay? So agricultural year as defined under section 2C of MP Land Revenue Code commences. Option 1 from 1st January, option 2 from 1st April, option 3 from 1st July, and option D from 1st September. 1st January, 1st April, 1st July, 1st September. Agricultural year commences from which day? What should be the correct answer? Question number 59. Its correct answer will be your option 3. That is from 1st July, right? Even in if you will follow Chhattisgarh Land Revenue Code, there also the agricultural year commences from 1st July. So its answer will be 1st July, right? Next question. Question number 60. Yes, Ankita Gupta ji, 59 ka 3 is the correct answer. Question number 60. Now, what question number 60 is saying? That who among of these is not authorized under section 168 clause 2 of MPLRC to transfer the whole holding through lease? Option 1, a married woman who is living below poverty line. Option 2, a married woman who has deserted by her husband. Option 3, a widow. And option 4, a person in service of armed forces of the Union. Now, this particular question number 60, at that time, this particular provision was available in your MPLRC. But as of now, this particular provision has been repealed. But still, I am just going to tell you the correct answer of this particular question, right? Who among these is not authorized under section 168 clause 2 of MPLRC to transfer the whole holding through lease? Option 1, married woman who is living below poverty line. Option 2, married woman who has deserted by her husband. Option 3, a widow. And option 4, a person in service of armed forces of the Union. So what should be the correct answer? Any idea? Question number 60. Yes. Its correct answer is your option 1. That is a married woman who is living below poverty line. Now, this particular question number 61. This particular question falses in uno, falses in omnibus. Principle of falses in uno, falses in omnibus is, right? Option 1, rule of law. Option 2, rule of caution. Option 3, not applicable in India. And option 4, both second and third. Now, let me tell you, this particular question has been deleted by MP High Court in 2017 exam, right? This particular question has been deleted by MP High Court in 2017 MP Civil Judge Prelims ka question paper. Falses in uno, falses in omnibus is option 1, rule of law. Second, rule of caution. Option 3, not applicable in India. And option 4, both second and third, both of them, right? So what should be the correct answer? Yes, can anyone tell me? Question number 61. Ankita Gupta ji, 60 ka you are saying 4. No, 60 ka 1 is the correct answer, right? So what should be the correct answer for this particular question? Ideally, if we are going to replace this 3 with 1, then in that case there are chances that its answer may go to 4, right? So it is a rule of caution and not applicable in India. This is what was the actual idea, but it should be like all these, like it is a rule of caution and it is applicable in India. So it's this particular whole question got deleted, right? This whole question got deleted by MP High Court. Next question, the conduct of the accused. 61 का देखिए 3 is also correct, 4 is also correct. The reason behind this particular question's options are disbalanced. Next question, the conduct of the accused is relevant under. Conduct of the accused is relevant under option 1, section 8 of Indian Evidence Act, section 10 of Indian Evidence Act, section 11 of Indian Evidence Act and section 12 of Indian Evidence Act. The conduct of the accused is relevant under section 8, section 10, section 11, section 12. What should be the correct answer? The conduct of the accused is relevant under section 8, section 10, section 11, section 12. So if you remember the particular provision which was stating that previous and subsequent conduct of the accused are relevant. So they are relevant under which section? Yes, 62. What should be the correct answer? So its correct answer is option number 1A, that is under section 8 of Indian Evidence Act, the conduct of the accused is relevant. Next question, question number 63, that is discovery of fact under section 27 of Indian Evidence Act includes 1. The object produced, 2. The place from which the object is produced, option 3. Knowledge of the accused to existence of that object, option 4. All of these or all of the above. Question number 63, what should be the correct answer? A discovery of fact under section 27 of Indian Evidence Act includes option 1. The object produced, option 2. The place from place from which the object is produced, option 3. Knowledge of the accused to the existence of that object, option 4. All of that. Question number 63, what should be the correct answer? So yes, Ankita Gupta ji, 62 ka 1 is the correct answer. Question number 63, its correct answer is your option 4, that is all of these or all of the above, right? So a discovery of fact under section 27 of Indian Evidence Act includes the object produced, the place from where the object is produced, the knowledge of the accused to the existence of that object. All of these are relevant. To prove call details report CDR of the mobile calls, conditions of which section is to be fulfilled? Option 1, section 63. Yes, Ankita ji, 4 is the correct answer. Question number 64, to prove call details report, that is CDR of the mobile calls, conditions of which section is to be fulfilled? Option 1, section 63. Option 2, section 65. Option 3, section 65B, and option D, section 67. So the conditions of, yes, Harshvardhan Gautam ji, 63 ka will be 4, not 2. Question number 64, ठीक है? To prove the call details report of mobile calls, conditions of which section to be fulfilled? 63, 65, 65B and 67. What should be the correct answer? So if you people have read section 65B, then you will be knowing that it is providing the conditions to prove majority of the electronic transaction including CDR, that is call details report, right? Next question, question number 65. How many witnesses are required to prove a fact? How many witnesses are required to prove a fact? Question number 65. Option 1, 2, option 2, 1, option 3, at least one of eyewitness and complainant. Option 4, no particular number. Question number 65. How many witnesses are required? Yes, Vinny ji, 64 का 3 is the correct answer. Question number 65. Yes, Harshvardhan Gautam ji, 64 का 3 is the correct answer. Question number 65. How many witnesses are required to prove a fact? 2, 1, at least one eyewitness and complainant, and no particular number of witness. Yes, Ankita Gupta ji, 64 का 3 is the correct answer. So its correct answer, question number 65, correct answer will be no particular number of witnesses are required. Next question. Question number 66, that is, according to section 3 of Indian Evidence Act, court does not include. Court does not include. Yes, option 1 judge, option 2 magistrate, option 3 arbitrator, option 4 person legally authorized to take evidence. According to section 3 of Indian Evidence Act, court does not include judge, magistrate, arbitrator, person legally authorized to take evidence. So if you will read section 3 of your Indian Evidence Act, you will get the idea that the court does not include a arbitrator. ठीक है? So 66 का correct answer will be your option 3, right? That is, the court does not include the arbitrator legally authorized to take evidence. So its answer will be option 3. Yes, Vinny ji, Ankita ji, Harshvardhan Gautam ji, 65 ka 4 is the correct answer. Now, next question. Question number 67. Facts judicially noticeable. Harshvardhan Gautam ji, yes, 66 ka 3 is the correct answer. Question number 67. Facts judicially noticeable. Option 1, to be proved like other fact. Option 2, to be proved like special fact. Option 3, not to be proved. And option 4, to be proved as an expert opinion. Yes, Vinny ji, Ankita ji, Harshvardhan Gautam ji, all of you are correct. Question number 66, option 3 is correct. Now, facts judicially noticeable need option 1, to be proved like other fact. Option 2, to be proved like special fact. Option 3, not to be proved. And option 4, to be proved as an expert's opinion. So question number 67. If you will read section 56 of your Indian Evidence Act, you will come to know its correct answer should be that fact judicially noticeable need not to be proved. So its correct answer will be your option 3, right? Under section 56. Next question. Question number 68. Yes, Vinny ji, Harshvardhan Gautam ji, Ankita ji, all of you are correct. 67 ka 3 is the correct answer. Question number 68. A fact is said to be not proved. Option 1, the court either believe it does not exist. Option 2, the court considers its existence so probable that a prudent man under the circumstance of a particular case to act upon supposition that it does not exist. Option 3, court believe its existence. Option 4, when the facts are neither proved nor disproved. They are asking, now here you have to understand what they are asking. They are asking when we can say that a fact is not proved. Not proved पूछा गया है हमसे, ठीक है? So before answering the question, read the question very much carefully. Sometimes what happens कि when we try to solve the question quickly and we create mistakes. So question number 68 में हमसे पूछा गया है not proved. So if you will follow the provision of not proved, you can easily find the answer that when the facts are neither proved nor disproved, it can be simply said that the fact is not proved. So its correct answer will be your option 4, right? Next question. Question number 69, that is, Under section 146 of Indian Evidence Act, which kind of questions cannot be asked during cross examination? Option 1, to test the veracity of the witness. Option 2, to discover witness's position in his life. Option 3, to shake credit of witness. Option 4, previous sexual experience of victim of offence of rape. So under section 146, ideally, like, you can ask the question relating to veracity of the truthfulness of the witness. You can definitely ask the questions to discover the witness's position in his life. You can also ask the question to shake the credit of witness, but you cannot ask the questions relating to previous sexual experience of victim of rape. So its correct answer should be yes. 68 Harshvardhan Gautam ji, 4 is the correct answer. Ankita Gupta ji, yes, 4 is the correct answer. Question number 69, its correct answer should be under section 146, its correct answer should be your option 4, that is previous sexual experience of victim of offence of rape, right? Next question, question number 70. As per section 141 of Indian Evidence Act, a leading question means option 1, any question informing the answer. Option 2, any question suggesting the answer. Option 3, any question directing the answer. Option 4, any question declaring the answer. Now, if you will read question number 70, so they have played a mind game. The students who have read the Bare Act very much carefully, only they will be in the position to answer this question. A leading question means any question informing the answer, any question suggesting the answer, directing the answer, and declaring the answer. 69, yes, Harshvardhan Gautam ji, Ankita ji, both of you are correct. So its answer should be 4. Now question number 70. Now I am quite eager to see how many of you are in the position to mark the correct answer of question 70, right? So its correct answer is any question suggesting the answer. Okay, here they have played the word play. Okay, informing, directing, declaring, more or less all of these three are having the same meaning as suggesting. But if you will read exactly section 141 of Bare Act, you will come to know that it is the word used over here is suggesting the answer. Yes, very good, Harshvardhan ji. Now next question, question 71, whether a judge can ask during examination of witnesses. Whether a judge can ask questions during examination of witnesses. Option 1, no. Option 2, yes. Option 3, judge should sit as a spectator during the recording of evidence. And option 4, none of the above. So option 1, no. Option 2, yes. Option 3, judge should sit as a spectator during the recording of evidence. And option 4, none of these or none of the above. So question number 71, what should be the correct answer? Its correct answer is yes. Definitely the judge can ask question, right? Next question, question number 72. Newspaper report is a evidence. Option 1, hearsay. Option 2, circumstantial. Option 3, primary. Option 4, secondary. Yes, Ankita Gupta ji, 70 ka 2 is the correct answer. B is the correct answer. Question number 72. Newspaper report is a evidence. Option 1, hearsay. Option 2, circumstantial. Option 3, primary. Option 4, secondary. So newspaper evidence is which type of evidence? It is merely a, yes, Ankita Gupta ji, 71 ka 2 is the correct answer, that is yes, the judge can ask question, right? Now next question, question number 72. So its correct answer is a newspaper report is merely a hearsay evidence, right? Now Let's move further. Which of the following is not a competent witness? Which of the following is not a competent witness? Option 1, dumb. Option 2, deaf. Option 3, minor. Option 4, a person unable to understand questions put to them or unable to give rational answers to those questions. Right? A person unable to understand the question or unable to give answer. ठीक है, rational answers to those questions. So what should be the correct answer? हाँ जी. Question number 73. What should be the correct answer? Harshvardhan Gautam ji, 72 का its answer should be 1. That is a hearsay evidence. Question number 73. Its correct answer is option number 4. That is, a person unable to understand the questions put to them or unable to give rational answers to those questions. Right? Next question. Question number 74. C child was born after the dissolution of marriage between F and M. The legitimacy of child, 73 का yes 4 is the correct answer. Both of you are correct. Harshvardhan ji, Ankita ji. C child was born after dissolution of marriage between F and M. The legitimacy of child C will be taken as conclusive proof only when child C was born within dash days after dissolution. Option 1, 280. Option 2, 290. Option 3, 295. Option 4, 300. So, if you people have followed up section 112 of Indian Evidence Act, you will be knowing the answer of this particular question. That if a child is born within 280 days of dissolution of marriage, there is a conclusive proof of legitimacy of child. So its correct answer should be your option 1. Right? Next question. Question number 75. That is, which evidence is not a secondary evidence? Which evidence is not a secondary evidence? Option 1, copies made from original. Option 2, copies compared with original. Yes, Ankita Gupta ji, you are correct. 74 ka 1 is the correct answer. Copies made from the original. Option 2, copies compared with the original. Option 3, counterparts of the document as against the parties who did not execute them. Option 4, counterparts of the documents as against the parties who execute them. ठीक है? Yes, Harshvardhan Gautam ji, 74 का 1 is the correct answer. Question number 75. Which evidence is not a secondary evidence? Option 1, copies made from the original. Option 2, copies compared with the original. Option 3, counterparts of the documents as against the parties who did not execute them. Option 3, counterparts of the documents as against the parties who execute them. So question number 75, what should be the correct answer? So counterparts of the parties, counterparts of the document as against the parties who execute them. Against them it is not a secondary evidence, against them it is a primary evidence. So its correct answer is your option 4. Next question, question number 75. Yes, Harshvardhan Gautam ji, 74 ka 1 is the correct answer. 76. This particular question is first question from Indian Penal Code, IPC. Right to private defense extends to. Right to private defense extends to. Option 1, defense of body only. Option 2, defense of property only. Option 3, defense of body and property both. And option 4, none of the above. Defense of body only, defense of property only, defense of body and property both, and option 4, none of the above. Right? So question number 76. What should be the correct answer? If you will read like section 100, section 103, even section 97 especially of Indian Penal Code, you will be in the position to get the answer of question number 76. So its correct answer is right to private defense extends to both. That is defense to body and property both. So its correct answer should be your option 3. Right? Chali. Next question, question number 77. Under section 320 of Indian Penal Code, which of the following kind of hurt is not designated as grievous hurt? So under section 320 of IPC, which of the following kind of hurt is not designated as grievous hurt? Option 1, emasculation. Option 2, privation of any joint. Option 3, permanent disfiguration of chest. Option 4, disallocation of tooth. Option 1, emasculation. Option 2, privation of any joint. Option 3, permanent disfiguration of chest. Option 4, disallocation of tooth. Question number 77. What should be the correct answer? Emasculation? Yes, 76. Harshvardhan Gautamji is saying 3. Yes, Harshvardhan Gautamji, 3 is the correct answer. Under section 320 of IPC, which of the following kinds of hurt is not designated as grievous hurt? So its correct answer is option 3, that is permanent disfiguration of chest. Now rest all other categories are defined as grievous hurt under section 320, but there is no discussion of permanent disfiguration of chest. Question number 78. Dowry death is an offence under option 1, section 304A of IPC, option 2, section 304 of IPC, option 3, section 304B of IPC, and option 4, section 302 of IPC. So yes, Ankita Gupta ji, 76 ka 3 is the correct answer. Question number 78. Dowry death is an offence under option 1, section 304A of IPC, option 2, section 304 of IPC, option 3, section 304B of IPC, and option 4, section 302 of IPC. So question number 78, its correct answer is your option 3, that is under section 304B of IPC, dowry death is an offence. Right? Chaliye, let's move towards next question, that is voluntarily causing hurt on grave and sudden provocation to a person is punishable under. Voluntarily causing hurt on grave and sudden provocation to a person is punishable under option 1, section 331, option 2, section 332, option 3, section 333, and option 4, section 334. What should be the correct answer? Section 331, 332, 333, and 334. Voluntarily causing hurt